This is Here's How, Ireland's political, social and current affairs podcast, presented by William Campbell.
Thank you for downloading episode 48 of Here's How. There are active campaigns running at the moment to repeal and retain the Eighth Amendment to the Constitution. But how and why was it enacted in the first place? In this podcast, I'm talking to a long-time pro-life campaigner about her views on why it should be retained.
Here's How is Ireland's political, social and current affairs podcast. Make your view heard. Just dial 076 603 5060 and tell the world what you're thinking. Your voicemail may be included in the next podcast. You can find tips on recording your contribution and other ways to contact the show at here'show.ie/call.
On a Skype line now, I have Niamh Uí Bhriain of the Life Institute. Niamh used to be Niamh Uí of Youth Defence, but I think we're all long out of short trousers at this stage, so no more Youth Defence. Niamh, there is a campaign both to repeal and retain the Eighth Amendment, and that is the amendment that was instituted in 1983 that concerning abortion. I'm taking it that you are on the side of retaining the Eighth Amendment. Am I right?
Yeah, absolutely, Will. You're correct there. And I think one of the first things that people perhaps aren't familiar with in regards to this debate is what the Eighth Amendment actually says. Mm-hmm. And what it says is that the state acknowledges the right to life of the unborn and, with due regard to the equal right to life of the mother, guarantees in its laws to respect and, as far as practicable by its laws, to defend and vindicate that right. Mm-hmm. So what people voted on in 1983, and it was approved by a very substantial majority, 67% of the people who voted approved the amendment to the Constitution. What they were voting on was recognising that the unborn child was a member of the human family and that had an equal right to life as do the citizens in this country. Mm-hmm. And so that's what people voted on in 1983.
Okay. I want to go a little bit back before that as to where it came from. And when we both were very young indeed, or maybe not even born, there was two Supreme Court decisions, one of them in the United States in 1973 and one in Ireland in 1974. The US one was Roe versus Wade, and that said under the privacy provisions of the United States Constitution, people had a right to have an abortion if they wanted to do that within certain limits. And the McGee versus Attorney General case in the Irish Supreme Court in 1974 legalised contraceptives for married couples, also on the grounds of privacy. It basically said that the state didn't have a right to invade the marital privacy of private individuals. And out of that sprung what was called the pro-life amendment campaign, because people in Ireland, or some people in Ireland, were concerned that if contraceptives could be legalised on the basis of privacy, and abortion had been legalised on the basis of privacy in the United States, then abortion could be legalised in the same way in Ireland. And this came to a head when there was several elections in a row in 1983. The government was perceived as being weak because no government had a real majority, and this allowed various different campaign groups, including the pro-life amendment campaign, to push their case. Peter Sutherland, who was then involved with Fine Gael, proposed a wording which would say, very simply, in a single sentence, nothing in this constitution shall be invoked to invalidate a law on the ground that it prohibits abortion. And that's to say, if somebody went into court and said, under the constitution, I have a right to have an abortion, they would be pointed to a new provision that said, oh no, you don't. And that wording was opposed by the pro-life amendment campaign, and they promoted a different wording which in kind of political instability was supported by Fianna Fáil and was the one that, as you said, was eventually passed. And it said, the phrasing which you gave there, it says, the state acknowledges the right to life of the unborn with due regard to the equal right to life of the mother. And
sure.
Yeah, go ahead.
I think one of the things that's important that perhaps I didn't touch on was that the amendment didn't give the unborn child a right to life. It just acknowledged the child's right to life. And that's a very important distinction, of course, in human rights law and in our understanding of human rights. No government gives them to us, or, Enda Kenny or referendum can't take away our human rights. They're simply something that is inherent within all of us.
This is an essentialist view of human rights.
Yeah, that, they're inherent. We all have them. They can't be taken away. Even, if you're living in a totalitarian regime, you still have them. They might be denied to you, but you still have them. And so with the amendment, what the state was doing, what the constitution of the people were doing was recognising this right to life. I think in regard to what happened in the state is that I think many people were taken by surprise at the Roe versus Wade ruling, in that it used the right to privacy to bring in a very broad abortion law. And we can see now in the United States there really is abortion on demand without any limits. Abortion is available through all 3 trimesters of pregnancy. Mm-hmm. And obviously this is, ancient history for both of us, I think, William. Yeah. But then when the McGee judgment happened, just as you said, people were fearful that the right to privacy here might also be interpreted as allowing a right to abortion. But I think in fairness to the Pro-Life Amendment campaign, what they were seeking to do here was to also ensure that the people had the final say on this issue. Because very often, and we've seen this, very clearly in recent times in regard to other issues like water charges, like USC, like the bailouts of the banks and that, very often governments can act against the wishes of the majority of the people, or can act according to the wishes of very vocal pressure groups or outside authorities and that. And so what the Pro-Life campaign wanted to ensure was that this would be a constitutional amendment which could then only, of course, be changed by another referendum, by another vote by the people.
Well, that's true. That's true of any constitutional amendment. But I just want to
well, this is a very important.
Just one point on that. They not only did the referendum as was proposed, it didn't just say that there is no right to have an abortion. It said that essentially abortion is unconstitutional. Not only can the individual not go to the state and say that I have a right to have an abortion, the state can say to the individual, you actively do not have a right to have an abortion, and the state couldn't change that, as you say. They couldn't then go around and legislate around it. It would
exactly.
take another referendum.
Yeah, and I think that's a positive thing. I think the people should decide on major issues like this, just as it is on, for example, in the EU, being a member of the European Union, on all of those other really key important issues which impinge greatly on the human rights of Irish citizens and on how we live our lives. I think it's important to just come back to what you said about Peter Sutherland and that, because with the conflict that arose between, Fine Gael and Fianna Fáil at that time. And obviously this is my reading of history, but I can see why those who proposed the wording which was eventually inserted into Article 43.3 were adamant that that was the better wording, because it covered what you would call medical interventions, in that it made it very clear that women were entitled to any medical interventions which they needed in order to preserve their lives during pregnancy.
I want to come on to that in a bit, but I just want to cover one other. We will get back to that.
Yeah, but I think it's important to point out that from the beginning that view was there. That mother and baby had an equal right to life. So nobody was saying, for example, in the case of ectopic pregnancy, in the case of sepsis or cancer of the uterus or anything like that a woman couldn't get a medical intervention, to which she is, of course, entirely deserving, and which she always received in Ireland since the amendment was passed.
Okay. At the time of the debates, Alan Shatter, who was a Fine Gael backbencher at the time, he's also a lawyer, he said that the irony is that if this, that is to say, the eventual wording, if it becomes part of our constitution, it will essentially secure a constitutional judgment in the not too distant future requiring the House to enact legislation to permit women to have abortions. Whatever you think of Alan Shatter, he was bang on with his prediction, wasn't he?
Well, I don't know if he was, because I think the Supreme Court ruling in 1992 was a surprise to almost everybody. In that not only they were really being asked to consider, I suppose, a right to travel, and they interpreted the Constitution then as allowing a right to abortion where a woman said she was suicidal. And
well, I should maybe just explain the background to that. In 1992, so not quite 10 years after the referendum, there was what was called the X case, where a child, a 13-year-old girl, had been the victim of a rape and had become pregnant by the rapist. Her parents took her to the UK to have an abortion. This was obviously a horrendous situation. And at the same time, They made inquiries with the Gardaí. They reported the matter, obviously, to the Gardaí. They made inquiries, could DNA be taken in order to convict the rapist, because, of course, that would include the rapist's DNA, and that the person was known to the family and was later convicted. This was passed up the chain, and it got as far as the then Attorney General, who was under a Fianna Fáil government at that time, and a court order in the High Court was sought and given, saying that the family who were in the UK at the time were required to return to Ireland without having an abortion under threat of legal sanction. So the constitution was being interpreted to have extraterritorial effect, that they must return and obey the Irish constitution even while they're outside in the UK. This caused uproar amongst pro-choice groups who thought this was an appalling treatment of a young child. I'm sure you wouldn't disagree with that, at least in some aspects.
Well, I don't think
I think it was also that people like yourself and other pro-life people thought that this was an overextension of the law. Would that be correct?
Yeah, I don't think anyone envisaged that Article 43.3, the Eighth Amendment, would be used in that way, and that was subsequently there was a subsequent referendum then in 1992, which caused some concern for people, because it was being sold as purely a right to travel, but it was inserted into Article 40.3 of the Constitution. So there were some legal questions about that. But certainly I don't think that was the intention of the original amendment. The intention of the amendment was to protect the right to life of the unborn baby and the right to life of women. And it's interesting that you're raising what people said around that time, because there were some very wild claims made by people who opposed the 83 amendment. They were saying that women would die as a result of the Eighth Amendment, that women would be denied cancer treatment as a result of the Eighth Amendment, and other things.
But also in 1982, people did say that people would be refused permission to leave the country under that amendment.
Can I just finish my point? Like, you had leading campaigners like Dr. Maura Wood saying that women who had cancer would be denied treatment for that cancer in Ireland if the amendment was passed. And clearly none of this was true. Now, women in Ireland, after the Eighth Amendment was passed, right up until today, if you have cancer and you are pregnant, you are not denied any treatment that you need. And we all know women who've had treatment for cancer while being pregnant in Ireland under the 1983 amendment. And thankfully, very often they and their babies have survived. And, I would point to the fact that the amendment in many ways served medical practice very well. That it challenged doctors to continue to view both the pregnant woman as that there were two patients involved. They used the two-patient model, and to ensure that they could protect and best serve both mother and baby.
Okay.
And that's the nub of what the amendment was all about.
Okay, can I just go back to what happened in 92, because I think a lot of people won't remember it, and it was very significant that there was this High Court case. Whether you agree with the ruling or not, that was the High Court interpretation of the 1983 amendment.
Sure.
This was then appealed to the Supreme Court, and the High Court decision, if left stood, if it was allowed to stand, would have meant that it was possible to seek an injunction to prevent any pregnant woman intending to get an abortion, and possibly any pregnant woman at all, because you couldn't see into their mind, to prevent them from leaving the state. And the Supreme Court came up with, I think what both of us will agree was a very strange decision, and perhaps you might and I might think that it was under pressure. The Supreme Court, which can overrule the High Court, said that yes, the High Court is correct to say that they can both prevent women from leaving the state and indeed order a woman, or a child in this case, to return to the state and not have an abortion. But because this child had said that she was suicidal, that her right to life, and this is where the equal right to life of the mother in that referendum was brought up, her right to life was equal, but then perhaps a bit more important than the unborn child, and she was on that basis permitted to have an abortion by the Constitution, and in fact guaranteed the right to an abortion by the Constitution be that abortion either in the UK or indeed in Ireland. Do you think, and I guess I'm correct in saying that you, as I, thought that was a very strange ruling. Do you think that it might have come out of pressure, or maybe internally? I'm not saying that anybody was getting on the phone to Supreme Court justices, but that they felt that they had to solve this problem and they were approaching the case with an end in mind, and they wanted to find a way to get to that end rather than necessarily go the way the law would have taken them unguided?
I'm not sure, because I couldn't guess as to whether they came under pressure or not, to be honest, William. I think that the ruling, as you said, there was a lot of very strange things in it, not least in that, the Supreme Court came to this decision without, for example, consulting with psychiatrists. Mm-hmm. They heard from one psychologist who was a supporter of an abortion rights movement, the Irish Family Planning Association. They didn't hear from psychiatrists. So they interpreted the equal right to life as a mother and child as not really being equal when it came to suicidal ideation. And, it took another 20 years, I suppose, until 20 years, in 2013, when the Oireachtas Committee hearing heard from psychiatrists who all agreed that abortion is not a treatment for suicidal ideation arising in pregnancy. So it seemed to me that the Supreme Court ruling, first of all, was really not, it wasn't made based on solid evidence, and that it was a misruling, and that you can't have an equal right to life of mother and child and then say, well, we're going to put it to one side in the case of suicidal ideation, and we're making that decision without hearing any evidence in that regard.
Niamh, I think you're right on that, but I think that it goes to the heart of a problem within the Eighth Amendment, because it says that it guarantees the right to life of the unborn with due regard to the equal right to life of the mother. Mm-hmm. And essentially what courts have to do is they have to balance rights. And if you and I, God forbid, were on opposite sides of a court, the job of either the judge or the jury is to decide who wins. And the law is there to tell the judge and in this case a judge, the principles and the practices of how to make that decision. And a law that says we're both equal, not only it doesn't help them to make that decision, it actively is preventing them from making that decision, because our legal system is adversarial, and one side or the other has to win.
But for example, all of us who are born have an equal right to life, and that's established in law, and judges have to balance that all of the time as well. Mm-hmm. I do think that very often in arguing around this issue, there's a kind of a false dichotomy, like this conflict between the mother and the baby. Because, we are lucky that medical advances are now so good.
Sure, I agree with that, and I understand. No, but just return for a moment, Niamh, to the issue that when the Eighth Amendment says that two rights are equal, that is of no assistance to the court in making a decision.
But I think it is, because what the court has to do is to recognise that here are two human beings, and that one's life is not more valuable than the other. And I think that's from a human rights point of view, that's a very fundamental principle. Mm-hmm. And then what courts would need to do is, like, for example, in regard to the X case, which was a really tragic and horrible case, nobody wants to face into that difficult situation, is that they should have looked, for example, at the evidence. Was there medical evidence to support a point of view that abortion is a treatment for suicidal ideation? Mm-hmm. And there isn't, So, to me, not only the reasoning in the case, but how they went about hearing evidence and everything like that led to this misinterpretation of the Eighth Amendment.
Mm-hmm. There was then, shortly after that, 3 referendums. We've actually, in our lifetimes, we've had 5 referendums already on abortion in Ireland. That's because 3 referendums very quickly followed that. One of them said it was essentially freedom of information, that said that people could not be prevented by the Eighth Amendment from receiving information about abortion abroad. The second was freedom of travel, that said that people could not be prevented to travel abroad to have an abortion. Both of those passed, and those 2 referendums then overturned that Supreme Court claim of extraterritorial jurisdiction, that you could say to Irish women, not only can you not have an abortion in Ireland, you can't even go outside the country to have an abortion. There was a third referendum in that which would have made that very small amount of abortion which was permitted in the Constitution, that is to say, to save the life of a mother, that would have restricted it, theoretically at least, very slightly, to save the life of a mother, not counting the risk of suicide. And it's difficult to interpret how the people voted on that third referendum, which failed, because people on your own side, Niamh, campaigned against it because although it went from having a very tiny, from permitting a very tiny amount of abortion to permitting an even tinier amount of abortion, it didn't permit zero abortion. And I think on that basis, I don't want to speak for you, but I think quite a few pro-life groups campaigned against it on that basis. And also pro-choice groups, because it was restricting an already very, very small right to an abortion. It was further restricting that.
I think you had all the pro-life groups opposing the amendment in 1992, and again 2002. A lot of pro-life groups opposed the wording of that amendment, and each time it was because the government were being unclear about what they were proposing. And I think that this is a real issue for the government. No, I think it was unclear as to what would be envisaged. How it was envisaged that abortions could be carried out under the proposal in 1992, and I think that's
to save a mother's life, excluding the risk of suicide.
Yes, but I think what it did is that it created an element of vagueness around what exactly that required. And I think at the time, and we are going back 20 years now, at the time, people argued quite persuasively that vagueness was exactly the opposite of what was required, given the Supreme Court's interpretation of the Eighth Amendment, which people have considered to be very clear in this regard.
The one issue, and I know that you have very strong views on it, was that when Savita Halappanavar tragically died, the circumstances under which she died was that she had a very difficult pregnancy and was in the process of having a miscarriage. While the text may or may not have been clear, would you agree that Irish medics, doctors and nurses and so forth were reluctant to go even any way close to anything that looked like an abortion, and that delayed a treatment that could have saved her life?
No, I would not agree, and I think all of the evidence shows that understanding of Ms. Halappanavar's case is untrue. Savita presented at Galway University Hospital. She had a very normal pregnancy until then, by all accounts, but she was miscarrying her child, and as we all now know, after 3 inquiries into her tragic death, she was infected with a bacteria called E. coli ESBL, a very virulent bacteria, very unusual one to arise in pregnancy in this country, and one is difficult to spot and very difficult to treat. But in relation to Savita's particular case and to how doctors should have reacted, what we're dealing here with then was a case of sepsis arising in pregnancy, and the reasons why the medical team didn't intervene to deliver her baby and do whatever else was needed to save her life. And they might not have been able to save her life because E. coli ESBL is that severe and that virulent. But the reason why they didn't intervene is because they didn't realise that she had an infection, because they missed the signs. And we know this now after all of the inquiries, the coroner's court, the HSC report, that there were, at least 13 missed opportunities for her team to notice that she had sepsis and intervene. But coming right to the core of the matter, William, because this is the question, were doctors in Ireland, where sepsis arose in pregnancy, were they free to intervene? And had they intervened in other cases, just like Savita's, where without fear of the law and without fear of being accused of carrying out an abortion? Absolutely. And we know this is the case because Dr. Sam Coulter-Smith, who at the time was Master of the Rotunda, spoke to the Irish Medical Organisation's annual general meeting several months after the Savita case, and he very pointedly told them that 4 cases of sepsis, just very like Savita's case, except the bacteria wasn't E. coli ESBL, but 4 cases of sepsis had arisen in his hospital. So 4 cases of sepsis in pregnancy, and he had intervened in all of those cases in the past year. He'd intervened in all of those cases, and sadly in all of those cases the baby had died. And there was no question of that being described as an abortion. There was no question that he was not free to intervene in those cases.
Okay,
so,
I understand what you're saying, but what I want to do, and I know that you're somebody who gives this a lot of thought, and as a thought experiment, rather than a particular instance, as a thought experiment, in the instance, if the instance arose where an abortion would save the where an abortion would save the life of a mother, would you think that's justified?
You see, I think what people need to understand is that abortion is not medically necessary. And I say that
but as a thought experiment.
Well, I don't see the point in thought experiments when they're dealing in situations which aren't real.
Let me tell you the point of the thought experiment, because as you say, medical science is advancing all the time. Things change, and constitutions tend to be perhaps not set in stone, but they're certainly not, they don't develop as fast as medical treatments do. And if that arose, in principle, do you think that's acceptable?
Well, see, to be honest, it doesn't rise. You know, we've had a situation in this country for 30 years where abortion wasn't permitted. Women who had ectopic pregnancies, women who had sepsis, women who had preeclampsia, and we all know women who've been in this situation. None of them were denied treatment. So I don't want to add to this false dichotomy where we're eternally pitting women against babies, as if we can't protect them both, as if we can't look after them both, and as if our laws can't seek to protect them both. I mean, I think that's an admirable, modern, progressive point of view where we acknowledge, because science tells us these are two people involved in every pregnancy. Our laws should protect them both. We should protect them both. You know, we should be grateful that medicine has progressed to this point where we understand, you know, the humanity of the unborn child, where things like treatment for cancers can be carried out without harming the baby, where, you know, if babies are born prematurely because of interventions in regard to sepsis and other things, very often those babies can now survive.
Okay,
so
Niamh,
I think the law should look forward,
then.
not look back to like a time where perhaps women did die more often in childbirth because maternal health services were poor.
Okay, one last question in that case. Would you agree that the florid nature of the language in the Eighth Amendment was probably unfortunate, given that it was perhaps poorly understood at the time, and it was left itself open to being argued that it meant this and that, and it left itself open, for example, to the High Court and the Supreme Court, some of the most senior judges in the land, coming to a different opinion as to what it meant?
I'm not sure what you mean by florid. I know the word florid means, but would you describe it as florid?
I would, and this guarantee to vindicate well, for example, if you compare it to the proposed wording that came originally from Peter Sutherland, nothing in this constitutional shall be invoked to invalidate a law on the ground that it prohibits abortion. It's not very poetic language, but everybody knows what it means.
Everybody knows. I appreciate that. I think again what they're, and you know, I didn't put the amendment forward. I think what the proponents of the amendment were trying to do was to get the law to recognise a right to life. You know, it's not just about abortion or banning abortion. It was saying that the Constitution should acknowledge that the unborn child is a member of the human family, and therefore we recognise the right to life of that child. You know, I don't think anyone expected the Supreme Court to interpret it as it did. As I said, to my mind, it was a misinterpretation.
Niamh Uí Bhriain of the Life Institute, thank you very much for talking to me.
Thank you very much.
If you like the Here's How podcast, please rate and review the show on iTunes and other podcast providers. Share it on Facebook and Twitter. Tell your friends. But most of all, make your views heard. Call us on 076 603 5060.
That's almost the end of episode 48 of Here's How, Ireland's political, social and current affairs podcast, published on the 23rd of September 2016. There's a link to Niamh Uí Bhriain's website, the Life Institute, and other information in the show notes for this podcast on the website. If you can think of a topic that you think should be covered in the next show, or if you want to suggest someone to include, and that could be yourself, then let me know. If you like the podcast, please go on iTunes and give it a rating or even write a nice review. Also, please like the show on Facebook. Please follow the podcast on Twitter at Here's How Podcast. Follow the Life Institute at Life Institute and subscribe to the podcast, so new shows automatically come into your podcast feed. You can use iTunes, Stitcher, TuneIn Radio or any other podcast app or software. And if you don't know how to do that, there's step-by-step instructions along with contact details at www.here'show.ie. The next show will be uploaded shortly. The Here's How podcast is produced and presented by me, William Campbell. Thank you for listening.